A question I'm asked very often on my LBC show is, can the Department for Work and Pensions reclaim old historic benefits? Benefits that it says I was overpaid from 10 years ago, 15 years ago, 20 years ago. Can it attach my earnings? Can it get the money back directly from the employer rather than suing me? Now, for a long time I got this wrong. I thought the answer was no, the DWP can't change or can't charge for overpayments that are more than 6 years old, and the DWP can't go direct to your employer without getting a court order first, which it won't be able to do for debts that are over 6 years old. But I was wrong. Several people contacted me and said that I'd got this wrong. I researched it, and here is the actual position. The standard time in which debts can generally be reclaimed by the Department of Work and Pensions is 6 years, and that's because the county court will only issue judgments in relation to claims that are less than 6 years old. But debts can be reclaimed going back even further by the Department of Work and Pensions without limit if they seek to recoup that overpayment by way of a direct earnings attachment, because these don't require a court order and so aren't covered by the 6-year limitation period. Money you owe for benefits or tax credit overpayments can be taken directly from your wages using a direct earnings attachment. These were brought in by the Social Security Overpayment and Recovery Regulations 2013. Now, things you should know about a direct earnings attachment. Number one, there's no court order needed. Number two, your employer will get details of how much to take from your pay. And number three, the payments go directly from your employer to the Department for Work and Pensions. Now, the DWP, through its nominated company called DWP Debt Management, should write to you before starting the direct earnings attachment. Direct earnings attachment deductions are capped at 40% of your net income. You might be able to avoid the direct earnings attachment by agreeing payment instalments instead. And a direct earnings attachment can be used to recover benefit overpayments at any time because they don't require any court action. Guidance called Benefit Overpayment Recovery Staff Guide, which is available on gov.uk, link below, indicates that a direct earnings attachment will only be considered where a claimant is not in receipt of benefits which can be offset or hasn't agreed to repay the overpayment by other means. Paragraph 5.99 states, I quote, "A direct earnings attachment is only usually considered for debtors who won't agree a voluntary repayment plan." I'm still looking for a legislative provision which sets this out, but I don't think there is one. I think it's just the DWP's practice. So how do you challenge the DWP issuing a direct earnings attachment? Before the start of a direct earnings attachment, you will be provided with details of the overpayment decision by the DWP. And that decision normally includes the following: whether there's been an overpayment, who or what caused it, the period of the overpayment, the amount of the overpayment, evidence of how the overpayment has been calculated, whether some of the overpayment can or has been offset, whether the overpayment is recoverable, if so, who it's recoverable from, and the basis for that decision, and a decision on whether and on whom to apply a civil penalty. Now, if you don't agree with the overpayment decision or any penalty that is applied, you can request either a written statement of reasons, which is an explanation of the overpayment decision, or a mandatory reconsideration, or both. Any mandatory reconsideration of the decision has to happen before you can appeal to a tribunal, because it allows the DWP a chance to resolve disputes at an early stage by looking again at the decision along with any new evidence provided. It also avoids clogging up the tribunal process. If you want to make a request for a reconsideration, and you have to do this before you go to the tribunal, you should make it within a month from the day following the issue of the notice of the overpayment decision. Now, where the decision is successfully reconsidered, so where the DWP says, yes, we've got this wrong, any subsequent decision by the DWP replaces the original decision. And when the decision is changed, you have the right to request reconsideration again of that revised decision. If you still disagree with the overpayment decision following the reconsideration, you can appeal against the decision to the Social Security and Child Support Tribunal. You've got to do it within 1 calendar month of the day of the reconsideration decision. And you'll find the form, linked below, at www.gov.uk/appeal-benefit-decision/submit-appeal. The Social Security and Child Support Tribunal may decide to uphold the original decision by the DWP. They may uphold your appeal, or they might change the DWP's decision. Both sides then have the right to dispute the tribunal's decision by appealing to something called the upper tribunal if there's been an error of law, but that's pretty unusual. Any recovery already made, so any monies already clawed back, won't be refunded until the outcome of the reconsideration or the appeal is known. And if you're successful, then any over recovery made from your wages will be refunded. I hope you found this video useful. If you did, here are some other videos that you might enjoy. Thank you so much for listening. I'm Daniel Barnett. I'm a practicing barrister and the presenter of the Legal Hour on LBC Radio. Stay safe.